this is pretty much mask off, that this is an exercise of raw power to stifle dissent and criticism. It's got nothing to do with like the local affiliates being unhappy or anything that Kimmel said.
Yes. And look, I know that pointing out Republican hypocrisy is kind of a fool's errand, but two of the biggest Supreme Court cases in the last term, ending in 2025, were about the supposedly gross assault on the First Amendment when the government uses its power to curtail speech.
Welcome to Law and Chaos, where the First Amendment is still alive and well. Despite FCC ghoul Brendan Carr's best efforts, Lisa Cook is still on the Fed Board of Governors, and even FedSoc judges think the Trump administration is full of shit. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me as always is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I'm doing okay. You got exciting plans for this weekend?
I've got a couple of things, a little neighborhood block party. And
that'll be fun.
Yeah, it should be fun. What about you?
Probably not going to work that much, but TBD.
Always a promise, never delivered. So see if you can't touch a little grass this weekend, Liz.
Okay, but first, let's talk about Jimmy Kimmel, because God knows everyone else is. But actually, you know what? Before that, I want to talk about Brendan Carr, the chairman of the Federal Communications Commission and one of the greatest villains of this administration. And I say that in part because of what he's doing, but also in part because this is a person who knows exactly why what he is doing is wrong, right? Yeah. He was inside the FCC for a really long time. He knows how it's supposed to work, and he knows how the law goes. And he told Trump, look, put me in charge, and I will make this agency into a weapon to silence your enemies and enhance your power. And he wrote about it in Project 2025, and he sucked up to Elon Musk back when that jackass was at the center of the action. And now that Trump's put Carr in charge of the FCC, he's delivering on every promise. He is using this federal agency to silence Trump's critics and bend the media to his will.
Absolutely. Carr has launched investigations of CBS, ABC, and NBC for political bias, but not Fox, of course. And Carr has threatened to withdraw the broadcast licenses for stations which, quote, do not serve the public interest. Now, Trump shakes his fist a lot about stations losing their licenses. That's not really a power that the FCC has.
Oh, my God. Trump was losing his mind about that today, saying it should be illegal for all of these stations to be against him.
Yeah, I don't know what to say. If you need to be told that violates the First Amendment, you're probably not a show listener. But yeah, look, what Brendan Carr is doing is threatening to pull the licenses of local affiliates that are owned by the various networks. And he is using the power of his office to push on the pain points of these multimedia conglomerates, right? So the most public example of that to date was the CBS merger with Skydance, that consolidated control of both companies under Trump's ally, Larry Ellison, the founder of Oracle, and his son, David. That merger needed, among other things, FCC approval, and Brendan Carr weaponized that process to extract massive political concessions from CBS. CBS agreed to tilt its news coverage to be much more favorable to conservatives. It pretty clearly resulted in Stephen Colbert getting fired, and it led to CBS settling this absolute garbage lawsuit that Donald Trump had filed in Texas, claiming that it was consumer fraud for the TV show 60 Minutes to edit an interview with Kamala Harris, despite the fact that there are multiple legal decisions directly on point saying, yes, 60 Minutes edits its interviews. That's what it means to be on 60 Minutes, right? I mean, this was just absolute nonsense.
Right. So like 10 minutes after Colbert was fired, Trump said, I hear Kimmel is next. It clearly had nothing to do with Kimmel's comments about Charlie Kirk in the past week, which were so anodyne. This was the administration gunning for media critics and seizing the opportunity to take out Kimmel. Brendan Carr went on right-wing podcaster Benny Johnson's show Wednesday and said ABC needs to take Kimmel off the air or risk fines and license revocation for its local affiliates. I mean, he literally said, we can do this the hard way or the easy way, which is gangster shit, like totally antithetical to the First Amendment.
Right. And there's other stuff going on behind the scenes, just like in the Paramount, that's the parent company of CBS, Skydance merger. A company called Nexstar Media Group owns more than 200 local media stations. Plus, it runs the CW network, which apparently still exists, and News Nation. And so Nexstar wants to buy its rival, Tegna, which owns 64 media stations. And to gain approval for this $6 billion deal, they need Brendan Carr's sign-off. So when Carr said Kimmel had to go, Nexstar and Tegna said they were pulling Kimmel off of their affiliates. And also, Sinclair Broadcast Group, a long-standing right-wing media outlet that owns a bunch of TV and radio stations, they said they wanted Jimmy Kimmel out, and ABC just rolled over and fired him. Right? The Trump administration is literally leveraging the power of the government to stifle its critics and, while at it, make billionaires richer.
And decrease access to local media. I mean, that is one of the most insidious things about this. Carr is out there pretending that he's doing this because the content ABC is providing to its affiliates is inappropriate and unsatisfactory and pissing off local consumers. But what he's really doing is decreasing the power of local media consumers, right? Because all they're going to get are these massive media conglomerates owning all of the local affiliates and sanding off any of the coverage that they don't like, right?
Yeah.
It is pure power for power's sake. And of course, Trump is gleeful. He's now demanding that NBC kill off Jimmy Fallon and Seth Meyers. Like, this is pretty much mask off, that this is an exercise of raw power to stifle dissent and criticism. It's got nothing to do with like the local affiliates being unhappy or anything that Kimmel said.
Yes. And look, I know that pointing out Republican hypocrisy is kind of a fool's errand, but two of the biggest Supreme Court cases in the last term, ending in 2025, were about the supposedly gross assault on the First Amendment when the government uses its power to curtail speech. You call those the jawboning cases, right?
Yeah.
The first was Murphy versus Missouri, in which red state Republican attorneys general sued to prevent the Biden administration from trampling free speech, which they defined as government health experts flagging COVID misinformation on social media and asking Twitter and Facebook to take them down. The threat to the First Amendment in that case was so dire that the Fifth Circuit actually enjoined the government from talking to social media companies, from filing, right, from hitting the little button that says report misinformation. Although, to be fair, the Fifth Circuit did stay that order pending review by the Supreme Court.
Right.
And the Supreme Court tossed that case on standing 6-3. But Justice Neil Gorsuch penned a furious dissent for himself, Justice Clarence Thomas, and Justice Samuel Alito, in which Gorsuch said, quote, "Government censorship of private speech is antithetical to our democratic form of government." Yeah. And then the second of these cases that was decided on the merits was NRA versus Vullo. That was a 9-0 Supreme Court decision, which said the First Amendment prohibits government officials from relying on the threat of invoking legal sanctions and other means of coercion to achieve the suppression of disfavored speech. Now, that one got to 9-0 because that was a case in which the state of New York tried to penalize insurance companies for working with the National Rifle Association. Like, the speed of the conservative pivot from the government saying something is a lie is the biggest free speech crisis in American history to we will prosecute our critics. We can do this the easy way or the hard way. It's breathtaking in its hypocrisy, like, even for Republicans.
Yeah, it's going to be amazing to watch Gorsuch and the 5 other conservative justices contort themselves to bless this shit when it gets to them eventually. But I honestly, I can't see how this Kimmel thing will wind up in court, or at least not as a head-on challenge. I mean, maybe Kimmel would sue. I really don't know.
Yeah, that is, I agree with you, right? Kimmel has a breach of contract claim that I'm sure that CBS can work around. I mean, they can just pay him the money, right? That's not an issue. The public can lodge complaints about the Nextel merger. I have no idea it is really the insidious part of what the Trump administration is doing, because by making stupid threats and because the affected companies are capitulating in advance, even though the law is on their side, like there's just not a record that can be reviewed by the courts, right? Like, so if ABC, for example, had said, "Bring it on, asshole. Let's, why don't you try revoking our non-existent FCC license?" Then we would have the kind of case that it would there would be 9-0. There would be a Vullo case, right? Like it would be hard to imagine. It would probably be 6-3, right? But like,
who the hell knows?
Even this Supreme Court was not going to side with Donald Trump on doing a thing that's imaginary. But like, there isn't a record, there isn't a case because of this corrupt bargain that you've described, Liz.
Yeah, and I mean, ABC is owned by Disney, right? Disney wants stuff. And, they want it from the government, and this government will do exactly what conservatives have always accused Democrats of doing, which is picking winners and losers. Remember, they said that all the time about any time we wanted to subsidize clean energy, that was picking winners and losers. This, however, totally kosher. And I do not have a Hulu or Disney Plus subscription to cancel, but some of you out there might, and you might want to consider where you put your money, because I wouldn't want to subsidize this. I mean, I don't really watch network TV, so I can't really turn it off, but maybe you can.
Yeah, maybe.
Okay, and speaking of assaults on the First Amendment, Donald Trump has sued the New York Times for defamation. I mean, look, the suit is garbage. I'm not going to go into it super in depth here because I have written about it over at Public Notice. I shot a video about it, which maybe you will see tomorrow, maybe you will see the next day. But long story short, Trump is mad about a book by Suzanne Craig and Russ Buettner called Lucky Loser. And it details all of the ways that Trump got all these sort of lucky infusions of cash, not due to his own super genius business prowess, but because of his father's estate and because of The Apprentice. And he's really mad because he says, no, I made it all myself and I'm the biggest, smartest businessman in the world. And also he's mad at the New York Times just generally, right? Like the first paragraph of this lawsuit references the Times endorsing Kamala Harris, which he says is illegal or something.
It might be 3 years from now. I mean, who knows? But yeah, no, this is, even by Trump lawsuit standards. And I have to say, parenthetically, I'm really glad you didn't describe this with the inane ad damnum clause, right? The amount of money that Trump is saying that he's seeking, because as we have talked about on this show, that is entirely made up, right? Like this lawsuit says that the Trump brand is worth $100 billion.
Just his personal brand.
Right.
Just him.
Yeah, which exceeds the gross domestic product of 135 nations. That is not real law.
Right. So the case is filed in Florida. He filed it in the Middle District of Florida in the Tampa division. I suspect he wanted to get Catherine Kimball Mizell, Judge Catherine Kimball Mizell. She's like 12 years old. She's married to Chad Mizell, who works at the Justice Department. He did not get that judge. He got Judge Stephen Merriday, who is, I believe, a George W. Bush appointee. He's on senior status. We will see how this case goes. I'm not clear how the court can have personal jurisdiction over the reporters. It's Buettner and Craig plus Mike Schmidt and Peter Baker because they live in New York. Trump is suing the New York Times and Penguin Random House, which published the book. And I think that pretty clearly falls under Florida's long-arm statute because they do transact business in this state, but I'm not sure how, it's interesting. We see Elon Musk and we see other mostly conservatives trying to do this, kind of trying to establish national jurisdiction over anybody whose stuff can be read on the internet. So you and I could be hauled into court in Alaska on that theory because you can hear our show in Alaska. And that's not
Let's be real. The Northern District of Texas is where the administration is going to sue us.
Right. And look, Judge Reed O'Connor is indeed entertaining a lawsuit against Media Matters and refused to transfer it again, despite the Fifth Circuit saying, come on, give it up, Reed. He said, no, really, this is me. So this lawsuit is one of these kind of crappy lawsuits filed by three lawyers who are in Trump's regular retinue: Alejandro Brito, Edward Palcic, and Daniel Epstein. They're frequent flyers now that Alina Hobb is busy pretending to be a prosecutor in New Jersey. But
she's like locked in, her private bathroom in that New Jersey office, a la George Costanza at the end of Seinfeld, right?
Yeah, well, I mean, we've talked about this a bunch on the show because her appointment was pretty clearly illegal. It's not clear that anything she puts her name on is binding, has the weight of law. So it's just sort of ground prosecutions in the state of New Jersey, or at least federally, to a halt. But okay, go ahead and read the post. We'll link to it in the show notes, which I wrote a long post at public notice. And there'll be this video about the lawsuit. It's garbage.
We need our laughs where we can get them.
All right. We're going to be right back after this brief ad break, unless you are a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case, no ads for you. Not today, not ever. And we are back. Okay, let's talk about Donald Trump's efforts to fire Lisa Cook, the first black woman governor of the Federal Reserve Board.
Yeah, what are the odds the Trump ones are gone? Yeah.
Yeah, so Trump is, as you know, burning down the entire executive branch, ensuring that our government can't do anything but enrich the powerful and punish dissenters. And so he's firing everyone from low-level office workers to heads of federal agencies. And despite a ton of law and precedent, the Supreme Court is letting him do it.
Mm-hmm.
But the justices do seem to understand that undermining public confidence in the Federal Reserve could have serious negative economic consequences. And so they tried to carve out a not the Fed exception when they were letting him fire everyone. They sort of mumbled something about the unique history of the Federal Reserve in one of the shadow docket orders, in which they said that Trump could fire the head of the National Labor Relations Board. Yep. But Trump really, really wants to fire Lisa Cook, because she has a term that runs into 2037, and she fits the profile of people he doesn't like. So he dispatched one of his goons named Bill Pulte, who is the director of the Federal Housing Finance Agency and the chairman of Fannie Mae and Freddie Mac, because everyone in this shit show government wears 5 hats. Pulte has been sending his evil Oompa Loompas to comb through the financial paperwork of all of Trump's enemies, looking for something to damage them with. He's gone after Adam Schiff. Actually, the Post yesterday had a wild story about this effort Pulte started, which to indict the New York Attorney General Letitia James for mortgage fraud based on a document that was never submitted to a lender, which appears to have been a template generated by her lawyer. And in the document that it sits, she checked the right box. Everywhere else on the application, they just found this little piece of paper that was never submitted that has the wrong box checked. And by the way, the document's 20 years old. So Pulte has handed this referral off to the Justice Department to try and do something with it, as he has handed the referral off for Lisa Cook. I'm not sure what's happened with Lisa Cook, but it seems not to be going very well with New York Attorney General Letitia James. Anyway, Pulte, who's like heir to a real estate fortune, came up with some story about Cook claiming her vacation home as her primary residence, and Trump seized on that as a reason he could fire her, quote, for cause.
Mind you, there has been no adjudication in any court that Lisa Cook did anything wrong, much less illegal, right? This is entirely protection. We all know that, including the Supreme Court, but I guess that's not really a cognizable legal argument, at least not at this stage.
Yeah, I just want to interject a point on that, because the White House's sordid machinations to get rid of Cook aren't going to be what does or does not keep her in the job. And yet that's what her lawyer, Abby Lowell, concentrated on in his oral argument in the trial court, right? You and I were listening on the phone line, and I get like Abby Lowell is the most famous trial lawyer in the country right now, but that angle was terrible. The argument was terrible.
It really was. Fortunately for Cook, that argument was in front of Judge Gia Cobb in D.C., who's kind of, she's a Biden appointee, but she often does what you don't expect. Let's say it that way. And so Judge Cobb wrote an opinion that more or less ignored everything Abby Lowell said in court. She said that for cause has to mean misconduct in office, not before being sworn in. It was a long, frankly, impenetrable opinion that talks a lot about the 1933 Banking Act and subsequent amendments. I mean, that hit my geeky side pretty hard. Yeah. But it also leaned hard into the Supreme Court shadow docket order in Wilcox, in which the Supreme Court said, hey, the Federal Reserve is different. Please don't burn down our retirement accounts. So Judge Cobb, bottom line, granted Lisa Cook a preliminary injunction, let her stay on the job. The administration immediately appealed to the U.S. Court of Appeals for the D.C. Circuit and lost. That panel was Judges Childs and Garcia, both of whom are Biden appointees, and Judge Gregory Katsas, who was appointed by Donald Trump. That opinion was 2-1, and it broke down just the way you think. Childs and Garcia said that Cook has a property interest in her job and thus has a due process right to contest her termination. That is, Trump cannot summarily remove her based on cooked-up charges without giving her some form of due process, right? Notice and an opportunity to respond. Then this morning, the administration filed yet another emergency petition with the Supreme Court. They argue that the president's determination of cause is unreviewable by any court, non-justiciable.
Yeah, this is such a classic Donald Trump move. Like, we've seen him do this over and over. It's like the Humpty Dumpty presidency. He says, words mean exactly what I say they mean and nothing more. So, Venezuelan means gang member and trade deficit means emergency and boat full of fishermen, means drug smugglers. And he'll say, well, if I say it, that's what it means. And my determination is binding, can't be reviewed in court. And if anyone questions it, he just pulls the fire alarm and says, now it's a really big emergency. I have emergency powers to do what I want anyway.
I wish I could say, oh, Liz, she's so funny. That's her classic hyperbole. But that is basically the argument that Solicitor General John Sauer makes in his application to the Supreme Court. If Trump says this unproven allegation by Pulte, right, his own henchman is for cause, then that's beyond judicial review. And again, saying that this Supreme Court would have laughed Joe Biden out of court for daring to make such a claim, which is true, does no good, right? We're here now, but it is crazy to look at this.
Yeah. All right. Well, we are going to wait and watch to see what the Supreme Court does. My personal bet is that the conservatives give Trump what he wants tomorrow afternoon, right around the close of business. Maybe it's 5-4. Maybe they lose Chief Justice Roberts, who's still pretending he runs a legitimate shop up there at 1 First Street. But what do you think, Andrew?
I think, by and large, the court's 6 conservatives have been Trump-pilled, right? They know that they are going to get hammered for siding with this administration in virtually every single case. They're letting him burn down the government. So, at this point, right, it's them versus the left. What else do they have to lose from public reputation? I think I agree with you. I think that they've staggered a lot of these to come out at the close of business on Friday. I think it will be on the shadow docket with zero reasoning, staying Judge Cobb's order and drawing an angry dissent from the 3 real justices who are left on the Supreme Court.
Okay, we are going to take another ad break and we will be right back. And we're back. Okay, there is a ton of immigration news, and a lot of it, I think, is illustrative of where the Trump administration is sitting with respect to the courts. So let's start with this order from last week in New York by U.S. District Judge Lewis Kaplan. You may remember him from the E.G. and Carroll defamation cases.
I do, and Donald Trump definitely does.
Oh, yeah. So this case involves the, quote, temporary detention of immigrants at ICE's New York regional office at 26 Federal Plaza. That's an office building. It's not like a detention center. Basically, ICE has a couple of holding cells in there that they use for very short detentions. It's supposed to be for 12 hours or less, but now they're keeping people there for days or even weeks on end, penned up with insufficient food or water or medicine or hygiene supplies, not to mention no real means to access their lawyers.
Yeah, there have been a ton of arrests as public officials try and gain access to that facility in order to visit, as is their right. 10 New York City officials were arrested there today, Thursday, as we record this, including New York City Comptroller Brad Lander. It has really become a flashpoint for conflict, right? Especially after one of the detained immigrants got a video out showing men packed into this cell with open toilets, no beds, and hardly any place to sleep.
Let's listen to a clip of State Senator Jabari Brisport, who was arrested there today, talking about his experiences.
And I just want to say what I saw on the 10th floor today was both disgusting and cowardly. And I'm going to repeat what Comptroller Lander said. These men were so scared of us seeing how out of line they were, the inhumane conditions they were treating people with, that from behind closed doors, they zip-tied, the doors closed, and then used duct tape to cover any cracks for people to see. And then they laughed. And I heard them laugh about what they were doing. And they should be absolutely ashamed of themselves. So to be clear, ICE should be abolished. It has done nothing good in its 20-odd years of existence. And in the meantime, the New York State legislation needs to pass New York for all. Thank you so much.
Yeah, that is truly vile and inhumane. It is. There's no other way to say it. This is a moral stain on our country. I don't know how we can purge it.
Right. So Department of Homeland Security has been doing everything it can to prevent Congress from accessing these facilities, even though the law very clearly states that they do have the right to inspect facilities where immigrants are being held and they don't have to make an appointment in advance. ICE says, well, this isn't actually an immigrant detention facility. It's just a short-term holding, so, you can't come in. Despite the fact that ICE itself just announced a new policy that says short-term holding, which used to be 12 hours, is now 72 or longer in, quote, exceptional circumstances, whatever that means. So on August 12th, Judge Kaplan issued a temporary restraining order that said detainees at 26 Fed had to have 50 square feet of floor space, not including the bathrooms. They had to be fed, provided medical care, change of clothes, bedding, showers, and hygiene supplies. Because ICE literally took the position that toothbrushes were a safety hazard. You only had to feed people twice a day. Mm-hmm. They weren't supplying adequate toilet paper or menstrual pads either. Actually, one poor woman is awful. She testified that she bled through her clothes and had to wear them for more than a week in the room without a change of clothes, without a shower. And it was horrible, right? So the judge says ICE has to provide access to counsel as well. The government's argument is that they didn't have to do any of those things because it was temporary, which is not actually how the Sixth Amendment goes.
Yeah, and by the way, the government ran this exact same playbook in Los Angeles, right? It was stashing detainees in the basement of an office building. This is just not equipped to hold human beings. So then, last week, Judge Kaplan also issued a preliminary injunction. And I just want to read some of it because Judge Kaplan is really, really smart. And he's also, and I say this with complete respect, a cantankerous old goat. He will rip your throat out if you lie to him, which is not great if you're the Trump administration, particularly the DOJ lawyers who get dispatched to go tell the most inane lies to judges about all the illegal shit that the Department of Homeland Security is doing to deport every brown person they can grab up. Like Drew Ensign, we've talked about a lot on the show, the DOJ lawyer who told Chief Judge James Boasberg in D.C. that he didn't know if any of the planes full of Venezuelan men who were about to take off for SCOTUS, the torture facility in El Salvador. Right? Like his lies are sort of in a class by themselves, but the line attorneys are contorting themselves to situate their arguments in the cut, right? Where if you squint at them sideways and you don't parse the language too closely, they might maybe be true, but in actuality, they're mendacious bullshit, right? Like the whole basis of this is that the rules don't apply because this is an emergency.
Of the government's own making. They are the ones who decided that they had to, arrest thousands of people every week and take them into custody, right? If you are the government and you choose to conduct an immigration sweep that results in you holding all of these people, you have to house them in circumstances which comport with the Constitution and basic human rights.
Right. And Judge Kaplan will not let them get away with saying, well, this is an exception to the rule. So the order continues. Defendants have not defined exceptional circumstances. Their statement, thus, is ambiguous at best. Perhaps they regard the president's emergency declaration and promised largest deportation operation in the history of our country as exceptional circumstances in and of themselves. In that case, their position would boil down to the view that there are no time limits on detention in the 26 Fed hold rooms because everyone held there is held in exceptional circumstances. To use the vernacular, all bets would be off.
Right. So that's what we're saying, right? That Judge Kaplan is interrogating the language that the lawyers in this situation are using to paper over or to sort of cover over and make seem normal things that are not normal and not legal, right? He's saying you can't just say it's exceptional circumstances and say, well, we won't do it unless it's an exception, because if you haven't defined an exception, then there's no rule at all. Right. Judge Kaplan issued the TRO a month ago, and the government has said, well, there's no need for a preliminary injunction because everything's fine now that we're right. But as the court notes, Right, saying we're complying with your order so you don't have to like order us to do it anymore isn't so helpful, right? He says the defendants have given no assurance that the conditions will not revert to those described by declarants, or for that matter, worse, if the preliminary injunction were denied.
Right. So, as an example, the government submitted a declaration that said there's only 24 people in the room, right, as of August 18th, to which the plaintiffs responded with multiple affidavits saying, yeah, because they emptied the room right before they swore out the declaration, it's filled back up now, right? And also, pointing Judge Kaplan to the fire marshal's maximum occupancy limit was, like waving a red flag in front of a bull.
Right. I mean, yes, the fire marshal says you can fit 12 people in an elevator. That doesn't mean you can hold them in there for a week. Right. I cannot. Judge Kaplan picked up on that one, too. He was also super not impressed by this attestation that the average stay at 26 Fed is 2 days. Like, okay, 48 hours is still too long to be without medication or hygiene products or like barely any food or water. And B, saying the average is 48 hours means that some people are going to be in there a lot longer, and those people have rights that are being violated. Besides which, like, you don't average out constitutional rights. You can't just put one guy in there for 10 minutes and then have it balance out some other guy who's held there for 10 weeks, because that's the average, right? Like, the people who are there have rights.
Yeah, it's the economist with one hand in a bucket of ice and one hand in a fire, right? And I need to say, it is wild to contrast this with the way that courts in D.C., for example, have treated the Department of Homeland Security and the Department of Justice. I think it maybe has something to do with judges in D.C. adjudicating cases against federal agencies all the time, and, you know, everyone in D.C. being in and out of government, right? Like, they tend to take a 10,000-foot view, and they don't seem to get into the nitty-gritty in the way that judges who adjudicate between private parties are willing to. We saw in California, and we're seeing here in New York. Like, Judge Kaplan says, you've said there are medical personnel, but what does that mean? Do you have one EMT for the whole building? Or, you know, you say there's water available, but you don't say how they're supposed to drink it. Are you providing a cup? Or are you suggesting that, you know, they cup their hands in the bathroom sink and, like, you know, drink out of that?
Yeah, the affidavits here are so shameful and get at this, right? I mean, look, to be clear, this is the delta that the lawyers in this case are trying to exploit. They say there's water, but there isn't. I mean, if there's just water in the sink, what are you supposed to do? Stick your head under the faucet? And here, the affidavits say that the guards taunted the detainees and kind of held water bottles and squirted at them and told them to catch it in their mouths, which is, by the way, consistent with testimony from the Korean detainees who were arrested at that Hyundai plant in Georgia, right? The Korean press is horrified at the reports that these detainees were shackled at the wrists and forced to lap up water like animals.
Yeah, we will never recover from this.
No.
Okay, so Judge Kaplan certified the class of detainees at 26 Fed, and he converted his temporary restraining order into a preliminary injunction. He said, the court's preliminary injunction will not prevent defendants, that's the government, from pursuing the policies that they have set. It will merely require that they conform to the demands of the Constitution in doing so. It is up to defendants to choose whether they wish to expend resources to conform 26 Fed to those requirements, or to alter the rate at which they are funneling arrestees into 26 Fed and other facilities, or to select and obtain facilities where detainees can be held in a humane and constitutional manner. And right, so what he's saying is, you know, anticipating the argument to the Second Circuit and the Supreme Court of, you're interfering with the prerogative of the executive. No, right? I'm not interfering with the prerogative of the executive to conduct policy regarding immigration. I'm just saying you have to do so in the manner that's required by the Constitution. Oh, and one last point is I love tracking these.
Yeah.
Judge Kaplan set a bond for the plaintiffs in the amount of $10.
Yeah, so that's the reason that we're laughing is because the Trump administration has been trying to convince the courts that they are obliged to set a bond in the amount of the extra cash it will cost the government to comply. So in this case, the way the rubber would meet the road is that the plaintiffs would have to post a bond in the amount of, I don't know, whatever extra cost the government is going to be out if they have to, like, provide toothbrushes and, you know, menstrual pads and toilet paper for these detainees rather than just, like, caging them like animals. And that's the government's position, that if you want to appeal the denial of your rights, you have to compensate the government for it. And courts are just not falling for this shit.
Even this is foreshadowing the next segment a little bit, but even conservative trial court judges have said, no, that's not how this works. I mean, the government initially rolled out that argument when it was terminating billions of dollars in grants and saying, look, well, if the nonprofit can't post a $2 billion bond, then you, the trial judge, cannot enjoin the government because there's no way to make us whole if you're wrong and reversed on appeal. And trial court judges are like, get out of here with that argument.
Yeah, right. I mean, making a $10 bond is more of a middle finger than making a $0 bond. But I do want to draw an attention to something because it is Judge Kaplan. Part of the reason I believe that Trump made such a big deal out of this is that he was forced to post bond in his civil suits, not including the E. Jean Carroll suits, which were both in front of Judge Kaplan. So he had $87 million in damages, which he owed to E. Jean Carroll at the conclusion of the second trial. So he had to post a bond, which he did, and he had to post a really, really big bond, which for the verdict in the civil fraud trial in New York State, although that verdict has been knocked down and the appeals court, I think, obviated the need for him to post quite such a big bond. But you understand that he thinks, well, I had to post a bond to avoid collections while I was appealing these two civil suits against me. So if you want to assert your civil rights, why shouldn't you have to put skin in the game? And that's not the same thing.
No, it is not.
Right. Okay, we're going to take another quick ad break, and then we will be right back. And we're back. Okay, so this week, Judge Timothy Kelly, who is a 2017 Trump appointee, provisionally certified a class of all unaccompanied minor children from Guatemala and entered a permanent injunction preventing the government from whisking them out of the country without due process, based on the lie that the government is just reuniting these children with their parents.
Yeah. Right.
We've talked a bunch about this. This is L.G.M.L v. Noem. And it came across our radar when the government rounded up these Guatemalan children in the middle of the night, about 100 of them on Labor Day weekend, and loaded them onto planes. And they were stopped because Judge Sparkle Suknanen of the U.S. District Court, the District of Columbia, got out of bed in the middle of the night and issued a TRO with respect to the individual named plaintiffs and then certified the class. And she in fact moved the hearing up when the plaintiff said the kids are on the planes. So she, I think it's pretty clear, understood that when Judge Boasberg asked Drew Ensign, are there people getting on planes? And Drew Ensign said, I don't know. She wasn't going to let that happen again.
Yeah.
So she held this hearing at 12:30, moved the hearing up from 3 o'clock when they said the kids are on the planes. And it was Drew Ensign before her. And he said, I don't know. And she said, you know what? I'll wait until you do know.
Yes.
You go figure it out. And he came back. He said, I don't know. And she said, I will wait some more. And that is why the planes turned around. In fact, one of them was already on the runway with the children in it. And she then made the government file 5 status reports over the next 36 hours until each and every one of these children was accounted for and was put back into the custody, not of Department of Homeland Security, which is a deportation agency, but of Health and Human Services through its division, the Office of Refugee Resettlement, because that's it's humane. You know, the kids were actually in custody of ORR in foster care when they were snatched up in the middle of the night. But Judge Suknanen was the emergency duty judge over the holiday weekend. And once court reopened on Tuesday, the case was permanently assigned to Judge Kelly. And so we kind of wondered whether he was going to be as hard on the government or whether he was going to be deferential, right? I mean, he's not... Look, there are a lot of terrible judges. He's not Eileen Cannon, but he is a Trump appointee. He is a FedSoc guy.
Yeah, very conservative, long shot. Right. So let's draw that out a little bit because this is a larger issue you and I have talked about a lot over the past 8 months, Liz, and that is the question of the presumption of regularity, right? The default belief that the government is telling the truth in court and acting in good faith, which every other administration in our nation's history have enjoyed, right? Like, and that's because they didn't lie to the judges all the damn time.
Right.
But lots of judges, particularly those who did not spend their formative years marinating in FedSoc propaganda, aren't, right? They're not, according to Trump DOJ, that deference anymore. And, it's not just Democratic appointees. We have also seen a healthy skepticism from old school conservative, Ronald Reagan and George H.W. Bush appointees, a lot in senior staff. The guys you've called the old bulls, Liz, right? They also, by and large, do not trust this administration. But I think you and I both think that if the rule of law is going to survive the next 3 years, we're also going to need to persuade a bigger group of judges, right? We're going to need to persuade lifelong Federalist Society arch conservatives with whom we agree on basically nothing, that this administration can't be trusted, right? Those are George W. Bush appointees and many Trump appointees like Judge Kelly, right? Who's a real judge. I have practiced in front of Judge Kelly, right? Like, he's not an Eileen Cannon. He's a real judge. I'm sure we don't agree on much of anything, but if we can't persuade him, we're in trouble.
Right. And so that's one of the reasons we were paying a lot of attention during Friday's oral argument, because during the hearing with Judge Suknanen, Drew Ensign said that all of the children were being deported at the behest of their parents and the Guatemalan government, which was a bald-faced lie. Yeah. And that's why he didn't come back. As we've observed on this show, he often comes in, tells a nasty whopper, and then once it gets detected, doesn't appear again.
At the next oral argument.
Right. We've seen him do that in front of Judge Boasberg in the JGG case, in front of Judge Ixinas in the Abrego Garcia case, right? He's the guy they first send out, but he gets burnt pretty fast.
Yeah.
And so Judge Kelly asked Sarah Welch, the lawyer who took Ensign's place, do you stand by this story that Ensign said about the children being reunited at the behest of their parents? And she just said really quietly, like, we do not stand by that.
Right.
And I guess it's better than not. But I think if it had been Judge Boasberg that she tried that with, he'd have made a much bigger deal about it. He'd have said, what the hell do you mean you came in here and lied to me? But Judge Kelly just said, okay. And that kind of worried us when we were listening, because we thought he might be sort of trying to accord the government the deference that you would treat a litigant who wasn't lying to you all the time. And that, that has consequences, right? If Judge Kaplan had just taken ICE's word for it that there's medical personnel, instead of interrogating it, or if he hadn't said, like, what do you mean detainees have access to water, right? ICE would still be making those people drink out of the bathroom sink with their hands. It matters if the judge is going to interrogate what the government says or just take it at face value. So that was a little concerning. But in fact, Judge Kelly wasn't going to, jump on Sarah Welch, because I think he realized it wasn't her fault that Drew Ensign was a liar. But he wasn't going to let the government have, kind of rehabilitate itself and take advantage of the presumption of regularity. So in his order, he said, just before midnight on the Saturday of Labor Day weekend, several executive branch agencies began to implement a plan to expel from the United States certain unaccompanied alien children in the custody of Department of Health and Human Services and send them back to their home country of Guatemala. Those agencies told the children's caretakers who were hearing about the plan for the first time to have them ready for pickup in as little as 2 hours. The children were roused from their beds in the middle of the night and driven to the airport, where some were loaded on the plane.
Yeah, and you can see Judge Kelly's discomfort with this humanitarian tragedy, right? And you contrast that with the hearing where DOJ lawyer Sarah Welch said, it was regrettable, that was her words, that the children were yanked out of the bed in the middle of the night. And I mean, okay, +1 for not pretending that it was okay or offering some bullshit excuse as to why it was appropriate and necessary, but minus several million for the fact that your client is the one who did that, and that means the court should not treat you as a trustworthy party.
Right. So continuing, he says, the judge on emergency duty entered a temporary restraining order barring the agencies and their officials from removing or otherwise transporting the children from the United States. At a hearing later that day, counsel for defendants explained why it was fairly outrageous for plaintiffs to have sued. All defendants wanted to do was reunify children with their parents who had requested their return. But that explanation crumbled like a house of cards about a week later. There is no evidence before the court that the parents of these children sought their return.
Yeah, and as much as it's good to see Judge Kelly big as angry as we are, like, this opinion is not just rhetoric, right? Like, he granted the plaintiffs essentially all of the relief that they had asked for. So first, he provisionally certified the class of all unaccompanied alien children from Guatemala in and who will be in ORR, right? That is the Office of Refugee Resettlement Custody, who have not received a final order of removal or a determination of voluntary departure. So that means that each and every one of these kids will receive some sort of due process, right? They cannot just be swept up without getting to talk to a lawyer and go before an immigration judge.
Yeah, I mean, there's one thing that the plaintiffs didn't get, which is that they wanted the court to expand the class to all unaccompanied alien children from any non-contiguous nation, because we have a slightly different posture with nations that are our neighbors, our immediate neighbors, Canada and Mexico. Because it's pretty clear that the government has a plan to do this with Honduran children in the custody of ORR, to deport them under this same, like, oh, they're just being reunified. And so the plaintiff said, can you expand it to other children, particularly these Honduran children? But that was always going to be a tough ask for Judge Kelly, particularly because there's a case pending in Arizona called Kettlewell v. Noem involving these Honduran nationals, where the judge has also issued a TRO. But I think it is heartening to see that Judge Kelly, even though he said, I'm not going to do this thing, he also told the government, like, I have my eyes on you. Don't try it, right? He's saying defendants should not construe this decision as an invitation to take similar action with respect to the other unaccompanied alien children. Yeah. And I personally would interpret that as him saying, I will pick up the phone in the middle of the night if you try this shit, right? Don't do it. Do not try and put these kids on a plane in the middle of the night in, East Ass Crack, Texas. I will pick up the phone and I will stop you and I will be mad.
Yeah, I think that reading is exactly right. So the scope of the preliminary injunction that Judge Kelly issued says that the government is enjoined from transferring, repatriating, removing, or otherwise facilitating the transport of any plaintiff, including both named plaintiffs and all members of the provisionally certified class, right? And remember, that means any Guatemalan children that are in ORR custody and do not have a final order of removal or a final determination of voluntary departure, right? From the United States, right? So that is as broad a language as you can think of that says, no, they're going to stay here. And we will be back to break down the legal reasoning after our last ad break.
And we're back. Okay, so when we were reading you Judge Kelly's order, we talked about him saying that the executive branch agencies began to implement a plan, by which he meant together. Because the government's argument here, it sounds so crazy, but the government's argument here is that it is not the Department of Homeland Security that's actually deporting these kids. It's Health and Human Services. And Health and Human Services is not a deportation agency. Health and Human Services was the custodian of these children. And so, I was glad to see it in the order that Judge Kelly looked at this and said, no, you guys are doing this together. But the reason that the government wants to pretend that it is like Health and Human Services, the custodian of these children, doing the deportation is because of a law called the Trafficking Victims Protection Reauthorization Act, which specifically bars Homeland Security from doing what it did here. And so the way that the government has tried to get around this is by saying, well, HHS, into this like tiny little subsection of the law, has that authority to reunify these children with their parents. So this wasn't deportation, it was reunification. And that was such obvious bullshit. And I did not think that the judge was going to fall for it, but you never know.
Yeah. the government really tried to rest on this list of 9 criteria that it said that it had developed in order to determine whether a child was removable from the country or not. And essentially, Judge Kelly bought the plaintiff's argument and said, you may have invented this list of criteria, but, quote, nothing binds defendants to these criteria. They cite no statute, regulation, or even policy statement requiring them. That means there is no legal roadblock preventing the government from changing the criteria or how they interpret them tomorrow and hustling the child out of the country as they tried to do over Labor Day weekend. And then, right, he said, by the way, what the government has represented before me and my colleague, Judge Suknanan, in this court, quote, suggests that they are not applying the criteria accurately, consistently, or in ways that reflect good faith. So the bottom line, I think, is that Judge Kelly doesn't believe the government, and he shouldn't, right? And that, I think, is really encouraging as we are gearing up for this long fight for the rule of law. And some of the fights are going to be in front of conservative judges who are nevertheless real judges, right? And I think that this is another good example of where not giving up, right? We're doing the work, compiling the evidence, marshaling it in front of the judge, like made a real difference, right? In the lives of these kids.
Agree. Totally agree. All right, that is going to do it for us this week. Thank you guys so much for supporting the show. If you can, at patreon.com/lawandchaospod or lawandchaospod.com. Otherwise, we would love it, appreciate it, be ever so grateful if you would leave us a 5-star review on your podcast platform of choice. Have a wonderful weekend. We will be back on Monday with written content and on Tuesday with another show.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Ipsa Media, LLC, all rights reserved.